Good afternoon, everyone. Thank you for joining us today for the top 5 pitfalls to avoid during a workplace investigation. I want to tell you a couple of things before we get started, what to expect on this webinar. All of your phone lines are muted, so if you have any questions throughout the presentation, please type them in using the questions or chat feature. I will address all questions at the end of the webinar. I do expect today's webinar to run about a half an hour, and then we'll leave approximately 10-15 minutes at the end for those Q&A. You will receive a copy of the webinar within a few days along with some additional resources, and as always, we welcome your feedback. So if you don't mind, please take a moment to respond to the post-webinar survey. And there are a number of upcoming webinars, so be sure to check us out at convercent.com and see if there's anything you might be interested in. For those of you who don't know, my name is Lowry, and I do work for Convercent. We are a technology-based company located out of Denver, Colorado. I am the manager of our professional services behavioral science specialist for Convercent. My areas of expertise include conducting corporate investigations on a variety of employee misconduct topics, and I have an area of specialty in conducting workplace violence threat assessments for organizations. I also conduct corporate trainings on various topics, including workplace violence, sexual harassment, as well as process of investigation. So let's go ahead and get started today. This is the second half of a two-part webinar. Our first webinar was titled 7 Phases to Conducting a Workplace Investigation, and today we're going to highlight the top 5 pitfalls to avoid during those workplace investigations. For those of you who attended the first one, there will be a little bit of overlap, but those of you who missed out on the first one, don't worry. I'm going to provide enough information during this webinar so that you won't be lost in the information. So let's go ahead and get started. First pitfall, not having a sound investigative process. Before an investigation is started, you should have a predefined documented process or guideline. When litigation occurs, the court's looking to see that you use a consistent process to gather facts and reach a reasonable conclusion. They are going to attack your process if these cases go to court, so you want to make sure that you have something solid and documented. So what kind of things do we need to document in our investigative process? First, you want to have clearly outlined how complaints are received. Most organizations have some kind of open door policy. They allow employees to report concerns via management or even some kind of phone, internet hotline service. Some organizations use a voicemail system. That's kind of their anonymous method of reporting. So if employees aren't comfortable revealing who they are, there's a phone number they can call and leave a voicemail. This is not a recommended practice. Most employees are not going to feel comfortable using a voicemail system because they're having to leave the message and they don't know who's listening to that voicemail. And for all they know, it could be someone who's recognizing their voice. So for best practice, we do recommend that you have some kind of third-party hotline system so that employees really feel comfortable reporting their concerns and that they do have an anonymous method to use if they do want to report concerns that way. Next, we want to make sure to detail how we're going to assign out complaints as they come in. So who's going to be responsible for assigning those complaints? Now this is going to vary depending on how large your organization is and depending on the structure of your organization. Some people may have a dedicated investigations team. So no matter what kinds of issues come in, they're going to go to that investigation team. And then depending on what type of complaint it is, it may go to a different investigator. Most of us aren't that lucky to have a whole dedicated team of investigators. So sometimes it's going to get assigned out by department. So maybe if you have a workplace violence kind of security issue, it'll go to your security department. If you have an employee relations issue, it's going to go to HR. If we've got something that looks like litigation, maybe that'll go to the legal team, or you also have internal audit, maybe if we're looking at a fraud complaint. Some organizations may choose to assign complaints based on the type of complaint or even the seriousness of offense. So maybe certain types of offense are going to go to the legal department and then everything else goes to HR. Or maybe some things are heightened out to to the seriousness that it's going to go to a third party. So there's a lot of different ways to assign cases. You just need to figure out what's going to work for your organization and go ahead and get that documented down on paper. We also want to think about timelines. So when we talk about timelines, we're talking about our response time to the complainant, the completion, how long is it actually going to take to complete an investigation, and then all the way through to a written report. Generally recommended response time to a complainant be within 24 to 48 hours, about 1 business day. You want to make sure that you're responding to the complainant. Now, this doesn't mean that you're actually asking them questions. It just means that you're acknowledging, hey, I got your complaint, we're looking at it, and we'll get back to you. That's as simple as it is. Completion of the actual investigation. Now, this is going to vary widely depending on the case matter, how much time and resources you have to put towards it, how many interviews are we going to conduct. Generally speaking, for us as a third party, we tend to be able to wrap up investigations in anywhere from 2 to 5 days. Now, that's because we have the advantage of being a third party, and this is all we're doing. I understand that as internal investigators, you have many more priorities, many more tasks on your plates besides dealing with this one issue. So a general recommendation would be a week to 2 time frame to deal with an investigation. Now, you may vary outside of that, and that's okay. Just make sure that you're clearly documenting why there was any delay. And then you're going to provide a verbal report at the end of your investigation, and at the point that you complete that investigation, I'd say about a week is a good amount of time to then have your final written report in. So that's kind of the general timelines that we follow and have documented in our process. Importantly, you need to have your general steps or phases that you want to follow for your investigative process. In the last webinar, we went over the 7 phases that we follow here at Convercent. That doesn't mean your organization has to have 7 phases. You can have a combination of our phases, or you have something else entirely that works better for your organization. But generally speaking, you want to have steps that are addressing some kind of preparation for the investigation. You want to have a step that talks about how you're going to gather information, where you're going to get your resources from. You need to have some kind of guidelines in your step for how you're going to conduct interviews, and we'll go into that in a little more detail in our 4th pitfall. You'll have some steps related to how you're going to report the information, who you're going to report it to, who's going to make decisions regarding that particular investigation, and are we going to disperse corrective or disciplinary action. These are the most critical elements of an investigation that are going to come up in litigation. Lastly, you want to make sure that you're documenting the follow-up. So make sure that you're looping around with the reporting party, looping around with the accused individual, or other appropriate involved people. To document or not to document, people ask us about this a lot. What is best practice? How much information should you document? Best practice is to document everything. We document everything, every interaction we have with any individual, our interview notes, our step, our process. We document, and I'm just talking about writing down notes on a piece of paper of who we're choosing, why we're choosing to interview certain people. The more you document, the easier it's going to be to support why you did what you did 2, 3, 5, 7 years down the line by the time this thing gets to litigation. It's important to be consistent when you are documenting this stuff. Often we get the question of, well, isn't it going to be a problem if we're all supposed to be documenting stuff? Well, what happens when someone doesn't follow the process, someone doesn't document it consistently? Yeah, that's going to be a problem, and that would be something that you could get nailed on, which is why it's so important to not only have a process, but to train your investigators consistently in that process. That's why you only want to select few people doing these investigations so that it's easy to audit the process and easy to make sure that they are doing it the same way and the right way every time. If you have somebody who conducts an investigation once every 2 years, they're probably not going to catch everything. They're probably not going to get it all documented. So it's crucial to have team members that have the right experience and are properly trained in the way your organization wants to conduct these. Hard copy versus electronic, is there a preference? My preference is electronic. I do manage a team of investigators, so if we only have one copy, a hard copy file, it's going to be extremely difficult for me to check in on them, to see where they're at in their investigation, or even just to pull up some notes to see if I can help them. We maintain full electronic files in our case management system. This makes it very easy for me as a manager to jump into any investigation and see where my investigator's at. I can see what kind of documents they've gathered, I can see how many interviews they've completed, and see where they're at in their process. I can also see if there's any delays and why there are those delays. So technology really can help you out when you're trying to document this stuff. Also, if you have a solid case management system that's geared towards this type of stuff, then you can use that as your template. So you can actually have your process embedded into that case management system to ensure that every team member is entering everything consistently. And as long as they're following that technology template that you have, then they will be doing it at the same time every time. Second pitfall to avoid, not utilizing properly pooled resources. You need to have experienced and unbiased investigators. You need to have in your organization people who have done this before. If they haven't done it before, you've got to provide them with adequate training to make sure that they're doing it correctly. This can be very detrimental to your organization if you don't have the right skill level. If you're just a small company and you can't afford to get that level of expertise in on your staff, or you can't afford to send that HR generalist out for some additional skilled training, then you need to use third parties. You need to use general counsel and go above and beyond to make sure that you're getting it right the first time. Now, the types of resources that we're using should be based on a couple of different things. You want to think about the complaint, so what kind of a complaint it is to see who should actually be investigating it. I know that while I'm skilled at interviewing, I'm not the most skilled at actually conducting the fraud investigations, as I don't have that accounting background. I don't have those numbers background. So somebody could give me all that information and I can interview someone very efficiently, but I'm going to need somebody who's a fraud expert to help me investigate that. You also want to think about race, gender. So think about the comfort of the people you're talking to. If you have an individual, an African-American individual, complaining of race discrimination, they may feel more comfortable talking to someone else who's also African-American or a member of a protected class. I think the most common example that comes up is sexual harassment. So you have a female complaining that her male manager is harassing her. You need to have a female investigator in that room interviewing that reporting party. Now, it doesn't mean we can't also have a male, but it's something you really want to think about. We want to make sure that individuals bringing forward complaints are comfortable and don't feel like they're being re-victimized. You also want to think about the likelihood of litigation. So the higher likelihood that something's going to go to litigation, the more you're going to want to, that's the kind of stuff you're going to go ahead and contract out to a third party, really getting the legal department and general counsel involved to help with that. I talked about being experienced, also being unbiased. So I know I pride myself on being objective and unbiased. Even if you know that you can be unbiased in an investigation, what you need to look at is would other people judge your position or role as one that could be biased? Because if there's the potential to be biased, that's something that an attorney will try to call you on in litigation. So what am I talking about? When we have internal investigators, you may want to be weary of conducting an investigation related to those higher C-level employees. Those individuals can influence your employment. And so that's a situation where someone from the outside might think that you have the potential to be biased. Another good example, we all know that we have certain employees that may be complainers, or they tend to be consistently reporting concerns. Well, what happens when they consistently report these little issues, and then finally they have a bigger one, right? All of a sudden they start throwing out protected class, or they start throwing out disability, things like that. That should be a red flag for you. If you've previously investigated their other claims, you may want to take a step back and get a new person, a different investigator, objective third party in to look at the situation so that they don't have any backstory. They don't have all that information and know that person and can really take a fresh look. Again, I'm not suggesting that you would be biased in the approach, but if the question's out there, you're going to be asked about it. Next we have, the next slide shows a risk decision matrix. Now I know there's a lot of information on this slide and I certainly don't expect you to read it right now. We are going to provide this to you in a separate handout, so I encourage you to look at it when we send those follow-up resources. But just to give you an outline of how to follow this, you'll notice that there are categories listed on the left-hand side. Look at those categories, read them across, and figure out what risk level the particular investigation falls into. After you've walked through all the categories, you should be able to make a determination of where this investigation falls. When you have it falling in the higher or severe risks, that's when you're really going to want to look at getting someone else involved or making sure that you do have the appropriate level of expertise to handle it. Third pitfall is waiting. Waiting is a big one. We must always conduct a timely investigation. One of the biggest things that companies get nailed on is timeliness, particularly related to complaints that statutorily require an investigation. So looking at whistleblower complaints and Title VII complaints, among others. When you have those statutory complaints or complaints that may violate federal law, timeliness is one of the first things they look at. This not only includes how quickly you respond to the complainant, it's how long it took to wrap up the investigation through determination and corrective or disciplinary action. So this includes conducting an investigation at all. So it's not just about waiting too long, it's about did you actually do anything? Most commonly this is coming up with anonymous complaints. So oftentimes when an organization gets an anonymous complaint, they think they can brush it under the rug, or maybe if the person didn't share their name, it must not be serious, or they must not really believe it, it must be made up, and that's just not the case. We find that most anonymous complaints aren't anonymous because they're lies, they're anonymous because the reporting party doesn't know where this information is going to go and they fear retaliation. That's why they choose to remain anonymous. So it's important that when you get those anonymous complaints to look at them and attempt, have some due diligence to try to look into the issue. Sometimes you can't do anything. There's just not enough information for you to go off of, and that's okay. We just want to make sure we're documenting it. We received the complaint because there wasn't enough information, there were no names, we had no idea what department they were talking about, we were unable to get any farther. Sometimes you're going to have enough information to at least ask a few questions, so make sure you do your due diligence around those anonymous complaints. So, of course, those taking this training are well aware of the importance of investigating employee concerns. But this most likely is going to be faulted when issues are presented to management and they're not properly reported up the chain. It is crucial that we train our managers on how to recognize employee complaints and train them on how to know when to escalate issues. There are plenty of issues that an employee is going to report to a manager and the manager is going to deal with, and it's not going to be a problem. But there are certain issues that are not appropriate for management to deal with because we need to follow our documented process. We need to bring it to a much more serious heightened level. Now, how do we make sure that our managers are doing that is by training them. Nobody's going to go up to their manager and say, I'm Susie over here, and I think Bob over there is treating me differently because I'm a girl. It's just not going to happen that way. What's going to happen is Susie's going to say, I don't know, I just feel weird when I'm around Bob and he seems to treat me differently. Or it seems that I'm getting singled out by Bob and he doesn't make everyone else do the tasks that I have to do. Those are the types of comments that are going to be made, and those are the types of things we have to train managers on so they can read between the lines and get that escalated to HR or legal or wherever it's most appropriate. This goes into the Ellerth-Fogger defense. This is an affirmative defense that you can use to avoid liability. So this case, these are two cases and in the late 90s, and they really, what ended up coming out of it is the courts concluded that employers are responsible for the behavior of their managers. They can be held liable for the behavior of their managers. And not only that, but those managers are agents of the company. So if a manager is aware of a concern, it is just as if HR is aware of that concern. They're looking at it pretty equally. So that's why we've got to make sure that we're training these guys appropriately. So what do we have to show to get this affirmative defense? We need to show that we have an effective prevention program that the reporting party failed to take advantage of. I have a really good example of how this played out with one of our clients. So Convercent does offer some technology, and in particular, a hotline case management system. There was one of our clients who had a hotline. They promoted it equally to all their employees. They had an individual make an anonymous report through the hotline. The company needed to ask some additional questions in order to appropriately investigate. So the company went ahead and posted some messages via the message board asking for additional information from the reporting party. They didn't receive any response. A couple of days later, they went ahead and posted another follow-up message and still didn't receive any response. About 6 months down the line, the company was notified that they had an EEOC complaint against them, and the employee stated that they reported a concern and the company failed to respond. Well, all the company had to do, they contacted us, they pulled up that case within their own system, and not only could they show that they asked those questions, we had in there. So they actually were able to show that the reporting party logged back into the system after those questions were asked and failed to respond to it. And since that reporting party failed to take advantage of that program, they didn't have anything to worry about, and the EEOC left them alone. All they had to do was send them that audit trail. So that's one example of someone failing to take advantage of a prevention program. The other piece to the affirmative defense is providing reasonable care to promptly correct behavior. So meaning, once you become aware there is an issue, you're providing that reasonable care to fix it. So even if you're not sure if it's an issue, once you've been put on notice, we need to do things to make sure that the person isn't being subjected to the same behavior. So sometimes that means something as extreme as putting an accused individual on leave for the duration of an investigation. I know it's not the most favorable thing. I know we have operations to run, but sometimes that's what you have to do, is remove them from the situation until you can figure out more information. Always recommend putting them on paid leave pending the outcome of an investigation so that they're not being punished in any kind of monetary way. So you really can use technology here to support or even prove your defense. Now, the only exception to this affirmative defense is that it is not available if the behavior resulted in any kind of tangible employment action, so termination or demotion. So we can only use this defense if there was no tangible action. If there was some corrective action or disciplinary action, we can use it, or other kinds of behaviors. So point being here, take-home message, really to promptly and thoroughly investigate all complaints using that documented investigative process each and every time. Fourth pitfall, we need to know who to interview and when. We call this our batting order. So who are we going to start with? Who are we going to talk to in the middle? Who are we going to end with? You want to set it up based on facts. Always, always, always start with the complaining party. Sometimes you may have a complaint in writing and it may have a lot of detail in it. Doesn't matter. We still got to go to the reporting party and ask questions. There's always additional questions to ask. Oftentimes, I find that my complaining party doesn't really know what they're complaining about or even refutes their own claim during our interview. So it's always a place you want to start to make sure you have a good understanding of where they're coming from. Never, never, never then jump to interviewing the accused. There's plenty of people to interview between the complaining party and the accused. Why don't we want to do this? If you get information from the complaining party and then go and confront the accused with it, what's going to happen? They're going to say they didn't do it, and you're not going to have to judge differently except your complaining party over in the corner who said they did it. Now the cat's out of the bag. Everyone knows that there's an investigation, and it's going to make it much more difficult to interview people and get documentation after the fact. So you want to be very logical and detailed in what you do. So after the reporting party, consider talking with supervisors. Think about the supervisor of the reporting party, the supervisor of the accused. You'd be surprised at how much information they have. Certainly, we know a lot of people behave differently in front of their managers than they do in front of their peers, but management may still have some insight into who hangs out with who, who's been getting along with who, where individuals sit. They definitely can add some kind of context. They also frequently have a desk file, so a bunch of notes or information about someone that maybe they never escalated to HR, it never got serious enough to go in a personnel file, but it's information that's probably going to help you in an investigation. Interview all direct witnesses. Now, I do want to make a point here. When I say all direct witnesses, if we have a situation, someone made a comment and there were 2 people reported to have witnessed the comment, you better interview both those people. Pretty no-brainer there. We want to make sure that we're getting all that information. Well, if you have a comment that's made in a group of 50 people, does that mean we have to go talk to all 50 people? Absolutely not. So that's overuse of our resources. What we need to do is take a fair approach to who we talk to, try to find the most neutral people, so people who aren't allied with either side or aren't strong enemies with either side. Once we start talking to a few of those neutral people, if we have consistent information, good. You don't need to talk to 10, 20 people. You just need to talk to enough until you get a consistent story. If there are no direct witnesses, then speak to peers who might have been located in the area, or people who can comment on the general work environment or character of the complainant or the accused. If you end up getting in a he said, she said situation, you're going to have to rely on those character comments to help you speak to credibility. So it's important to get those at the beginning. Be balanced in who you choose for interviews as far as who might be an ally, who might be an enemy. And always think about the comparators. So particularly when we're looking at Title VII complaints, if you have someone complaining, you need to talk to all those people who are in the same protected class and people who aren't. For example, if we have a race complaint, say we have an African American making a complaint of discrimination, we need to talk to the other African Americans in the group to see if they're being treated the same way. Then we need to go talk to some Caucasian people to see how they're being treated. Because if everyone's being treated the same way, then it's not based on that protected class. And if only one person's being treated that way, it may also not be based on the protected class. So it's just really important to weigh out those different comparators. Last pitfall that we have is over-investigating. So you need to know what your standard of proof is. You should set the scope of your investigation at the onset. Details and facts can be overwhelming as we're walking through an investigation. If the scope is preset, you can always go back to that to keep yourself focused. All information that people report is important, but some might be unrelated to this particular case, or some may need to actually be broken out into litigation. We have to be able to figure out how to separate the noise from the information that's pertinent to our investigation. And one way to do that is to go back to our scope or our objectives that we're setting at the beginning of our investigation. Have to understand the standard of proof that you're making in order to ensure that you're not over-investigating. So there are varying standards of proof. Most people tend to think of the beyond a reasonable doubt, 99.9%, that we have to know beyond a reasonable doubt, this person did it, they have the smoking gun, and I have a picture of them doing it. That is just not necessary for our purpose. That's what criminal courts are held to. All we have to do is make a reasonable conclusion based on our good faith investigation. Our good faith investigation is that solid, consistent, documented process. As long as we use that process and reach a reasonable conclusion, we're good. Now, there is a happy medium here. A lot of people aren't comfortable with that lower level standard, and if you do have a case that you think might go to litigation, then you might want to go with that preponderance of the evidence, which is our 51%, so it's more likely than not. That's generally where most of our findings fit. But remember, to make an employment decision, you only have to do that good faith investigation, reasonable conclusion. Conduct the investigation until you have enough information to reach that conclusion. If you have consistent information, you don't need to go talk to 3 other people just to make your case more solid. When you feel that you've made a balanced approach and can draw that reasonable, more likely than not conclusion, then we want to go ahead and close that investigation. There's always the chance that new information might come to light, and you can always reopen the investigation. So how do we show good faith compliance in order to have a good affirmative defense? You must have employment policies prohibiting discrimination, harassment, that's basic federal law. You want to have policies talking about code of conduct and behavior expectations for your employees. You also must establish complaint procedures so that employees know how and where to report their misconduct. It's not enough to have your policies and have your procedures. You must also ensure that all employees have received them and have been properly trained on it. So how do you do that? Here's another good place come in. You can use any kind of policy management system. So you can send all your policies and have employees attest to those different policies, and you'll have it all documented. You can do the same thing with e-learning programs. Make sure they're going through their proper trainings. Make sure you're doing all the statutory required trainings on a yearly basis or every 3 years, whatever is required by law. And if you have that all through a technology system, it'll be very easy for you to track everybody, make sure everyone's doing it consistently, and then to prove that you did clearly communicate it. And then lastly, most important, the point of this presentation, promptly and thoroughly investigate all complaints. So those are the most common top 5 pitfalls to avoid during a workplace investigation. Review: not having a sound process, not utilizing proper resources, waiting, not knowing who to interview and when, and over-investigating. I know that we touched on a good variety of stuff there, and I was able to mention how technology can help you manage some of these pitfalls. Convercent does have technology resources that can help you in this process, as well as additional resources and third-party investigators. So if you do need any additional information on any of that stuff or just some additional resources, feel free to visit our website at convercent.com. All right, that's all I have for the presentation today. Looks like we went just about 35 minutes, so pretty much on time. We're going to go ahead and open it up for question and answers. If you have saved your questions, feel free to type them into the question or chat feature, and I'm going to just go ahead and start reading through some of them and see what we can't get answered. Okay. Do you recommend organizations that come under public record laws still document everything? That is a very good question. No, I do not. So public records law is very, that adds a whole twist to it. So if you are an organization that qualifies under that, you do need to think about what is going to be making it into that public record. For private organizations, it's much easier, right, because then someone's actually going to have to subpoena our records to get it. So that's a good exception. I do not recommend you document everything if you do fall under those public records law. I would definitely defer to your in-house counsel or employment lawyer to get direction on what you should or shouldn't be documenting. Let's see. Does it matter where you document your process? No. It doesn't matter a lot. Now, we're talking about our investigative process here. So this is not something that should go into your employee handbook. Other employees don't have any need to know that kind of information. So we don't want to publicly broadcast it to everyone that we have in our organization. It does need to be documented somewhere so that all your team members, anybody who may be conducting investigations, has easy access to it. So if they do want to review it or do want to know what what step they're on or how they're supposed to be documenting something, they can go ahead and refer to it. So we all are trained in our process, and I think at this point all of my investigators can probably pretty much flat out regurgitate the process, but we still have ours kept electronically, and then we also have it templated out in our case management system so that it's very easy for us to follow. Now, people who are outside of our group, can't see that documentation or don't even really understand the templated fact of it in our case management system. Okay, good question. Does using a third party make your internal team less credible? Absolutely not. Absolutely not. Now, there are many reasons people choose to use a third party. Sometimes it's, I don't even just want to touch that with a 10-foot pole, right? Sometimes it's just lack of resources. You may be more than qualified to do it, but you don't have the time to respond quickly. So you need to get somebody who can drop everything and get in there and deal with the issue. So just because you contract out to a third party doesn't mean you don't have the skill or expertise. What it does mean is that you're smart enough to understand when you either A, need some additional help, additional resources, or B, understand when some things may be above your expertise. And in fact, I think that gives you more credibility for when you do choose to do it internally, able to make that decision of when something might be out of your hands. It says, what types of situations would lead to a deviation from your process that's acceptable, and how would you document that? Investigations are quite the dynamic beast. So there are a lot of situations that could cause you to deviate from your process. And it's just a matter of really clearly documenting it. Again, we use our case management system to document it. You can document or within your notes. Some common examples for us, if we have a significant delay in our investigation, it's usually the result of people. So either we're waiting to get some kind of records, or maybe we have to interview a key employee who's on vacation, or maybe they're out on medical leave, and we can't require them to speak to us. So those are very good reasons why there might be a delay in our process, and we simply note that and note when they're supposed to return. Now, if at all possible, we would try to get around that, but if they're a key witness, then we just have to hold off and wait, and that's okay. Okay, assuming a case goes to trial, what is easier to discredit? Investigator training or process? That's a very interesting question. I think, I can tell you they're going to try to discredit both of those. So they're going to try and discredit your training. Where did you get your training from? Did you learn it on the job? Were the people who trained you really skilled and experienced enough to be training you? They're going to ask you all those questions. How many hours have you done this type of thing? And it's going to get down to the nitty-gritty of the type of case. Well, how many times have you investigated this issue? How many times have you investigated this specific section of this issue? They're going to try and discredit the process in the sense that they're going to try and ask you 5 different ways sideways of what your process is, and you've got to be able to say it the same way every single time. And as long as you are doing it the same way every single time, it should be difficult for them to discredit it. I have been deposed before. I have had to testify before. And I sound like a broken record up there. Well, what did you do next? Well, how do you know you did that next? Because it's our process, because we follow it every single time. Because it's our process, because we follow it every single time. Because it's our process. And if I didn't follow it that time, I would have noted why I had a deviation. That's how I know for sure. So I actually think the training might be easier to discredit. But, I guess it just depends on who you got up there. How long do you retain documents for? General best practice, there's really no solid case law on it, but general best practice is 7 years unless you've been put on notice that something is going to go to litigation. If something is going to go to litigation, then you do want to keep it indefinitely. So we keep ours for 7 years. Now, if you have, for internal folks, you're going to want to keep it at least 5 years after the person leaves the company. So, because there are statutes of limitation, but oftentimes those statutes get extended if the behavior is ongoing. So it's not just a 7-year. You do need to keep it after longer after they actually leave the organization. So not just 7 years since the point of the investigation. Do you recommend keeping handwritten notes if you maintain electronic notes? This is a great point of debate. I kind of chuckle here because we've had this debate many times within our own office. We keep our handwritten notes for the simple fact that, yes, we do then write it up in electronic format, but what happens if you get rid of those notes? People then can question what was in those notes that you did not put in your electronic file. Now, I think an exception to that is if you're just straight up scanning your notes. So if you take handwritten notes during an interview and you're going to scan those into an electronic file, I think that might be an exception there. But to just transcribe handwritten notes into electronic notes, that's not going to be acceptable, because if that reporting party, that complainant, remembers that you took handwritten notes and you can't reproduce those handwritten notes in trial, that's going to be a problem. That's going to cause your credibility to be, that's going to cause it to be looked at for your credibility. All right, I think we'll go ahead and get a last question here. Oh, actually I have two that I can answer kind of quickly. So first, is it appropriate to ask the reporting party to put their complaint in writing before your interview? I don't think it's inappropriate. You can ask them if they want to get their thoughts together. I certainly wouldn't require it, but I don't think there would be any harm in saying, hey, would you mind documenting that down and providing me that in writing? If they're not comfortable doing it, then fine. I wouldn't push it on them, move forward with the interview. Most people probably will go ahead and do it. So I don't think it's a problem to ask if they would mind putting it in writing. Just because they don't want to put it in writing, though, doesn't mean we can dismiss their complaint. We still have to move forward with our interview. Lastly, go ahead and answer our last question as we're coming up on our 45 minutes here. Do you tell an interviewee who made the complaint? No, we do not. You have no obligation to tell an accused individual who made the complaint. What you do have an obligation to tell them is you need to give them enough information to respond to the complaint. Sometimes that may include an identity of someone who's involved. I try to stay away from that as much as possible. Most of the time, by the time you get to that accused interview, they know what's up. They know what's going on. They know who made a complaint against them. So I let them bring the names up. So asking questions like, do you know why I've asked to speak with you here today? Are you aware that there's any concerns about the way you've been interacting with individuals? And let them identify the problem, and then you can continue talking about it. I certainly don't ever start any of those interviews saying, Susie is complaining that you're doing this. Tell me about that. It's just not the best way to get an interview going. You want to start much more general, much more benign, and get them comfortable until you get into the nitty-gritty. So I think that's about all we have for today. I really appreciate you guys joining us for the top 5 pitfalls to avoid during a workplace investigation. As I said earlier, we do have plenty of resources available and have some upcoming webinars. So check out our website if you want any more information. Again, that's www.convercent.com. Thank you.